Good morning, good afternoon, everybody. I'm Susan Morgenstern. I'm the senior attorney with the Center for Taxpayer Rights. We're doing a webinar today on tax collection issues. This is really important for all kinds of taxpayers, and you'll see in the material today how much room there is to litigate on behalf of our taxpayers. This is being done as a project of the Center for Taxpayer Rights' Low-Income Taxpayer Clinic LITC Support Center. We urge you to sign up with LITC Connect so that you too can volunteer and take cases. The panel today, we're going to be starting with Bob Probasco. Bob teaches at Texas A&M University, where he's been running the low-income taxpayer clinic there for approximately 7 years. Bob is looking for somebody to run the clinic with him. So if Texas is in your future, think about reaching out to Bob. Our email addresses are included in the materials. So our second speaker is Mary Gillum. She's from Legal Aid Society of Middle Tennessee and the Cumberlands in Oak Ridge, Tennessee. Mary's been with that project since about 2000, so close to a quarter century, where she's been an active litigator in the field of low-income taxpayer policy issues. Finally, we have Oliver Roberts, now with Jones Day, previously with Skadden. In his newly minted career as an attorney, Oliver has taken already 2 cases to great success, one of them being in the courts of appeals on a pro bono basis, one of them being the Culp case, which he'll be discussing at the end of his presentation. So thank you very much for joining us today, and we'll start with Bob.
Okay, thank you. I'm covering what happens before the CDP process that Mary is going to talk about in great depths. Can you go forward to the next slide? I wanted to talk about a couple of these, assessment and collection notices. Another thing that happens prior to the CDP process is that you may have forfeited by that time your right to dispute the liability as part of the CDP process. Mary is going to be covering that in her presentation. I'm focusing on assessment and collection notices. Next slide, please. So assessment, next slide. Assessment, for those of you who have not had much experience or exposure to tax controversy, is just the act of recording a tax liability in the government's records, saying for this particular taxpayer, for this type of tax, for this audit period, this is how much the taxpayer owes the government. Before that happens, you may be in the examination phase, but they have not yet made an official determination and final determination that that's what you owe, because you have a lot of opportunities before assessment happens to contest that. The assessment includes penalties and includes additional amounts, which are similar to penalties, and interest. Assessment is very important because it's a prerequisite for collection. It also starts the 10-year statute of limitations for collection. Before assessment, it is difficult for the IRS to get money in. Most assessments that we deal with are subject to deficiency procedures in sections 6211 to 6216 of the code. The IRS has to issue a notice of deficiency, and as a result of that, you are given an opportunity, you may or may not take it, to challenge the dispute in tax court without having to pay first. This is normally your only chance to dispute it, other than in CDP, as Mary will talk about, before paying. If you can't do it here in tax court or in CDP, you're going to have to pay the full amount and then file for a refund. Most assessments are subject to that, but there are some assessments that are not. Next slide, please. If you report the tax liability yourself on a tax return, obviously the IRS can go ahead and do that because you are telling them and basically authorizing them to. There are a lot of things that they can correct other than that, though, without going through the assessment procedure that gives you a lot of rights. If you report withholding or estimated tax payments on your return, but the IRS did not receive that money, they can correct that. Criminal restitution orders are another category that they can make an assessment of without giving you the opportunity for prepayment dispute in the tax court. The really scary part for many of us working in this area are what are referred to as mathematical or clerical errors. In the very beginning of that provision, those were actually mostly math errors. You filled out the return, you were supposed to add and you subtracted instead, or you multiplied incorrectly, they would fix that. And they would not have to go through the deficiency process. There is a right, it's not always communicated very clearly, for taxpayers when they get a notice that that's been done to contact the IRS within 60 days and tell them, reverse that assessment. I disagree with it. You don't even have to provide a reason why. They are supposed to, although we see occasional problems, but they are supposed to reverse it. If you convince them that what they did was wrong, that will be an end of it. Otherwise, it will proceed to a notice of deficiency. And again, you got a lot of protection rights before they can assess. The mathematical and clerical errors category, there are a number of different things. It's set forth in section 6213G2 of the code. And they also can do it when you file a tax return for 2025 and it has a loss and you're carrying that back to an earlier year. That's referred to as a tentative carryback. And if the IRS determines that that was incorrect because they audited 2025, and now what you carry back to 2023 is no longer right, they can automatically correct 2023. And they can also assess if you pay amounts in. If you send money to the IRS and say, this is for tax year 2024 or 2021, and they've audited you, but you didn't do anything to challenge that, you just sent them a check. In that case, they can go ahead and assess that, because otherwise they would show a balance due you because it hasn't been assessed yet in the accounts of the IRS. You can waive the restrictions of requiring a notice of deficiency. Oftentimes you do that in exam or appeals. And the IRS has special provisions that if they think you are about to abscond or give away your assets or whatever, they can make jeopardy terminations after the close of the tax year, or termination assessments during the tax year before you've even filed the tax return, because they need to get something in the system immediately. Those come with different collection protections that will not be covered today. It doesn't come up very often. If this happens to a client of yours, something is seriously, seriously wrong. Next slide, please. The next part of this, I'm going to talk a little bit about collection notices. This is the part where I stay calm for a while and then may start to rant a little bit. Collection notices are a huge, huge problem for taxpayers. Next slide, please. So the IRS makes an assessment, and then they start sending out collection notices to the taxpayer, asking them to pay up. Some of those notices are statutorily required, and they may have very specific legal consequences. Others are optional, but the IRS uses them anyway because they are trying primarily to persuade you to voluntarily send money in. It's probably the most cost-effective collection tool the IRS has because the computer is spitting those out. Taxpayer gets them, They don't have to assign a revenue agent to or a collection agent, a revenue officer to come and harass you. They don't have to make a levy. They don't have to issue a statutory lien, notice of filing of the tax lien. So it's a very low cost. And the last year I recall seeing statistics, the IRS collected about $8 billion associated with the collection notices. It's still a small part of the overall tax gap, but it is pretty cost effective. Next slide, please. Here's the first one, the CP 14 notice. It's a notice of assessment and demand for payment. The code requires it to be sent out within 60 days of assessment, but typically they mail them. Actually, they may mail them on a Friday or Saturday before the assessment is going to be entered into the system on Monday. If you don't pay after demand, that creates a statutory lien. It's often called the secret lien, because you don't get a notification. They don't file anything with the courthouse yet. But that is triggered by that demand. If they don't send that out, the statutory lien does not exist yet. And also, failure to pay within 10 days after notice and demand authorizes the secretary to collect by levy, actually seizing assets from you. The statute says if you don't pay within 10 days, they can levy, but there are a lot of other limitations on the levy, and that's what we're talking about over the course of this presentation. If the assessment was a result of a waiver of the deficiency process, a notice of and demand is not made within 30 days of the assessment. It's very rare, but it happens occasionally. In those cases, they get an interest-free period on which they don't have to pay interest on the amount they have to eventually pay to the government. Next slide, please. These are the next two in the series, the CP 501 and the CP 503. Sometimes they only send out one of those. They are not statutorily required, but again, they are used to attempt to get voluntary payment without having to resort to more coercive measures, contacting the bank to get money out of your bank account, contacting your broker to get your investment account or retirement account. Again, this is cost effective, and they use increasingly strong language, which really gets heavy in the two notices after this. Next slide, please. CP 504 is actually a statutorily required notice. Way back in the beginning, the code, Internal Revenue Code, stated that before levy, you had to give them a notice 30 days before you the IRS actually seized property of the taxpayer. This is the original requirement. In 1998, the collection due process rights were enacted, and that led to the following notice that we'll talk about in a moment. So now this allows levy, but only on property that is not protected by CDP rights. Even though the IRS can go ahead and seize those, there is still an opportunity for a hearing similar to the CDP hearing within a reasonable period of time. But again, this is, you know what they say, possession is 9/10 of the law. In these instances, they already have the possession of the money. They took it from you. Next slide, please. What are those limited categories? State tax refunds that can go out to the state taxing authority and say, if they have a tax refund coming, don't send it to them, send it to us. Amounts due to federal contractors. If if you're a business that does business with the government and is paid by the government, they can go out to whatever part of the federal government is paying you and say, the next time you're ready to pay a bill to this contractor, don't send it to them. Send the money to us because they owe us money. And there's also a disqualified employment tax levy. If you have had a CDP hearing for employment taxes in the past, for the next 2 years, they have an ability to levy on employment taxes through this process without CDP initially. You've already had one crack at CDP hearing. We're going to not allow that to you for the next 2 years. Next slide, please. Then you come to the final notice. This is the one that triggers your collection due process rights. Before this, you have no right to a hearing, a CDP hearing. It's not uncommon for taxpayers to respond to the earlier notices and request a CDP hearing, particularly the CP 504 notice. But they can't get that hearing until they receive the final notice. And this is one that is mandated by Section 6330 after the 1998 enactment of collection due process rights. There are two different types: notice of intent to levy and notice of your right to a hearing. And that has to go out at least 30 days before the levy. Those are typically on letter 1058, LT 11, or CP 90. And the other variety is around not a potential levy, but filing a notice of federal tax lien, that they will go out to the county courthouse where they think you may have property and file a lien. It's not going to affect necessarily your ability to sell your car, but it is most assuredly going to be picked up if you try to sell your house, and it will complicate things immeasurably. Those were big issues, particularly in the past when those notices also went to credit rating agencies. But this notice of a federal tax lien filing, they don't have to give you before they file it. They have to give it to you no more than 5 days after you file it. They file it first, and then they give you your right to a hearing. That is letter 3172. For several years, the IRS combined the 6331D notice, the CP 504, and the 6330A notice, or 6320A notice, into one single notice. They don't have to send out 2 letters, they only send out 1. Currently, they're separate. They changed that several years ago. I think just one final chance to scare you into sending money before they gave you the opportunity to delay collection by filing a request for a CDP hearing. Next slide, please. Problems with notices. This is where I start to rant. The notices are confusing and they're difficult for taxpayers to understand. They exaggerate what the IRS can do prior to the CDP hearing, to the point of being misleading or a scare tactic. They focus on requesting payments and scaring the taxpayers more than explaining you have payment alternatives. You can get an offer in compromise. You could get currently not collectible. You could set up an installment plan. You could get help from the Taxpayer Advocate Service. They may be able to help you resolve your dispute before any of these bad things happen to you. You can get assistance from a low-income taxpayer clinic. And you have the availability of a CDP hearing or post-levy hearing, or a CP 504, that will post lien, actually. I'm sorry about that. So all of these are things that would be very helpful for a taxpayer to know, but they show up at the very tail end. The new version of the CP 504, the first page is nothing about this is how much you owe. Pay it immediately by automatically allowing us to withdraw from your bank account. And the second page, they get into these are all the things that we can take from you, and they list everything: bank account, retirement account, investment account, your car, your home, et cetera, et cetera. And then they ask for payment again and say, oh, you could also pay by credit or debit card. You could pay by check if you don't want to do it directly from your account, but they're asking for payment again. Then at the bottom of the page in small type, not bolded, it says, well, you have 30 days to pay even for the property that you don't get a CDP hearing for. And you'll get another notice before we can take anything else. But that's at the bottom of the page. Information about assistance from TAS and low-income taxpayer clinics, that's on the very last page. And some taxpayers don't even get to that. That is my rant for the day. And I think the next slide is Mary's.
Thank you so much. The information you just presented is so important to know where you're at and how you're getting to the collection due process hearing. And I really appreciate Bob's eloquent and succinct presentation on that. And Bob, I know I'm talking about a couple of issues that are near and dear to your heart, so feel free to chime in on any of the slides if you want to add anything as we go through here. So we're going to talk about requesting the collection due process hearing. We've learned all the information from Bob that we need to know, so we know why we're at the process at the point where we can request a collection due process hearing and how we got there. So we'll go on to the next slide. And my first question would be, and it was when I was learning this, is what is a collection due process, or as we refer to the acronym CDP? What is a CDP hearing? Well, it's a hearing, or as the IRS likes to call it, an informal administrative conference, but it's a hearing with an IRS appeals officer, appeals settlement officer within the IRS appeals office. It has to be, once you get a decision that we'll talk about, it's something that goes through an appeals team manager, but it is a hearing or informal conference. Now, the appeals officer that is participating here must not have had any prior involvement related to the unpaid tax. If you have worked with, if you have knowledge that this appeals officer has been involved in this case prior to the hearing, you make that known and you can request a different appeals officer. So it's very important that this appeals officer not had any prior involvement in this hearing before. You're only entitled to one collection due process hearing for each year. So it's the case sometimes that your client might owe for 5 years, but the final notice of intent to levy that Bob talked about only references 1 year. So your CDP hearing is only for that year. Now, you may be able to bring up things at the hearing related to the other years because that's part of your collection alternative. But your hearing is only in reference to the year listed on that final notice intent to levy or the notice of federal tax lien filing. And those are the only years that you will have the right to judicial review if you do not like the notice of determination you get. It's really important to know this because you're able to give the client some comfort for the year that you received that notice, if it's within the 30 days that we're going to talk about that you asked for a hearing. But you may have other years out there that, if you're not careful, could come back to bite you because IRS is able to do things because they're not part of that CDP hearing. They're not listed in that notice of intent to levy or the notice of tax lien filing that you are appealing from. Let's go to the next slide. So what's the legal authority that we're kind of looking at here? We're looking at Internal Revenue Code sections 6320 and 6330, or 26 USC 6320 and 6330. Spend a lot of time looking over Treasury Regulation sections 301.6320-1 and 6330-1. Internal Revenue Manual 5.1.9 talks about collection, but if you'll add a 0.3 to that, or add the 3 after that point, that's the section that really talks about the CDP. And of course, there's an ever-growing body, as we will hear at the near the end today, of case law that's really relevant to this work. So we'll go to the next slide. So what is the time period for requesting a CDP? It's 30 days from the date on the notice. We'll talk, well, I won't talk about, but our third speaker will talk a little bit about equitable tolling, how important that is, and what's been some recent involvements in that area. But you may have the right to request a hearing outside that 30 days. It's known as an equivalent CDP hearing, and you have 1 year from the date on the notice to do that. Let's go to the next slide. So you heard me just mention equivalent hearing. So what is an equivalent hearing? Well, an equivalent hearing is just like your CDP hearing. It's an equivalent CDP hearing. It's an administrative hearing with the IRS Appeals Office. It's made outside the 30 days. So your client comes to you, it's day 35. It's too late to request your regular CDP hearing. You can ask for an equivalent hearing, but it must be done within the 1 year period commencing on the day after the date that the CDP notice was issued under 6330. Next slide, please. So what are some of the characteristics of an equivalent hearing? Well, there's not an automatic stay on collection action. The decision to take collection action should be reviewed by the IRS on a case-by-case basis. And often advocates must request that the IRS consider a stay on collection action because it's not automatic. So let's compare the two in the next slide. Before we do that, we'll look at a practice tip. Even if you timely request a collection due process hearing, I always like to put on the form that I'm asking for an equivalent hearing. And I also like to try to list any years that in that form that we still may be able to request an equivalent hearing. If something goes wrong and the IRS determines that your hearing request was not timely, at least you've checked the box and said, hey, I still want consideration as an equivalent hearing. You don't have to file another request. This may allow you to address other years that are not in the notice. And it's possible to have a CDP hearing for the year on the notice concurrently, really with an equivalent hearing for years that are not on the CDP notice if they are within the 1 year time period from whenever the notice was sent out that gave you the CDP rights on those other years. Again, like taxpayers who owe multiple years, which is often the case with our tax clinic. You will get 2 separate hearing decisions. One will give you the right to appeal the tax court, the one that was timely, the other will not. So let's move on to the next slide. All right, so here's our comparison. Collection due process hearing versus equivalent hearing. Collection due process hearing, that's the one you have to request within 30 days from the notice of the federal income tax lien filing or from the notice of intent to levy. And as Bob said, that the IRS has 5 days from the date they file the lien to actually send that notice out when it comes to the lien filing. Equivalent hearing has to be requested within 1 year from the date on the notice. With a CDP hearing, you do this by filling out the IRS form 12153 or other written request, and then we'll give you some best practices as well. But equivalent hearing, you need to make sure that when you're filling out the 12153 that you check the box for equivalent hearing, or make sure your cover letter asks for an equivalent hearing if your hearing is considered untimely. The request on a regular CDP automatically stays out collection action, but with equivalent hearing, it's looked at on a case-by-case basis, and you often have to request the IRS do that. The biggest difference, though, between these 2 types of hearings, because they're both CDP related, is the timely hearing. You have the right to judicial review with the United States Tax Court. You do not have that right to judicial review with the equivalent hearing. Let's go to the next slide. Okay, so beware. The IRS only has to send 1 final notice of intent to levy and a right to request a CDP hearing per tax period. They must send a notice for each period, but sometimes but they can combine the periods in 1 notice. So I've often received final notice of intent to levy that has 3 years on it. The next day, it's not unusual that I've received, and this has happened to me before. I've received a final notice of intent to levy for 1 year, and then another year, and another year. And I've had 5 separate different notices for the levies, and they all came separately. So I requested hearings separately, but sometimes they do combine the periods in 1 notice, which makes it a little bit more, a little bit simpler to respond to. You can just respond in 1. Next slide, please. And we've already talked about this. We'll go to the next slide. Okay, some practice tips. Occasionally, clients present you as an advocate with a notice of levy on Social Security benefits. It may even state on there you have the right to request a hearing. I don't see as many of these now as I used to see, but I do see them from time to time. And just be careful. This is probably not, this is not your final notice of intent to levy. A lot of advocates think that it is, and they request a hearing and they don't understand why the levy doesn't stop. So don't assume this is the first final notice of intent to levy. Review IRS account transcripts. That's very important to look and see. And the detailed review of that transcript will sometimes show that a collection due process notice was already sent and received by the taxpayer. And those CDP notices that are being sent out that we're referring to are notated on the account transcript that you can obtain from the IRS as a practitioner. So if you do get a CDP, if a CDP notice has already been set out on your case, or you receive this notice about Social Security levy, and you don't have the right for a CDP hearing, just a little notation what you need to do if that's your situation. I would prepare a collection information statement, either a 433F or a 433A or AOIC, 433A OIC. I would call the IRS Collections Department at the number listed here of 1-800-829-7650. And I would ask for collection alternatives such as currently not collectible placement and release of the levy or an installment agreement. You can still ask for and possibly get an equivalent hearing, but you need to take immediate action to stop the pending levy if you do not have the right to request a CDP hearing. So it doesn't mean you can't do anything, but you're not going to get the CDP hearing. And here's some things you can do if they've already received that CDP notice in the time period, the 30 days or the year has expired. Let's go to the next slide. So why request a CDP hearing? Well, there's a lot of reasons. I personally love CDP hearings. That's one of the things I get most excited about in my work because I know I've had an opportunity through CDP, and as our speakers will talk about, they've had opportunities as well as to make case law through this. And that's something that I know as a legal aid attorney, I like to do because I can't help everybody that needs my help. We have limited capacity. Pro bono attorneys don't make it very, very helpful to increase our capacity. So do encourage you to consider signing up with Community Tax Rights to assist with pro bono. It doesn't matter where you're located, since this is a federal area of practice, but we definitely can always use your assistance. But why request the CDP? One, you can have an opportunity to make some good law because this is an area that's constantly changing. A lot of people don't understand, and we work with the University of Tennessee College of Law and through their academic clinic, and I have students each semester who work with us, and they're shocked to learn that these things that we're talking about today did not exist before 1998. The IRS could just swoop in, take money out of your bank account without giving you due process, notice, and opportunity for a hearing. Those are the core elements of due process. And so now they have to do that, but it's not been around as long as people would anticipate that it has been around, this CDP concept. But it's a mechanism to stop proposed levies or to negotiate release of liens, which is really important. In some cases, not all, it is another forum to challenge the tax liability. And it's what I look at sometimes my backdoor way to the tax court to dispute something that the IRS has assessed against my client. It is an expedited forum. And I say expedited when you deal with the IRS outside of CDP, things seem to move slower. They move a little quicker with CDP, but it's an expedited forum to bring forth collection alternatives. It gives you the opportunity to work with one IRS representative, which is sometimes a wish list if you're dealing outside of CDP and you're going to different people within IRS collections. It's a great opportunity to have that one-on-one conversation. It offers you a chance to deal with more knowledgeable and more experienced IRS representatives who are at a different pay grade, different level within the IRS. And sometimes they're even attorneys, which is nice because you can have a really productive conversation with people who are really knowledgeable about the law and the process. But most importantly, by far, it gives you the right to judicial review, whether you exercise it or not. That's some leverage that you have. And the IRS appeals officers, many of them are keenly aware of that. And I think that helps guide you sometimes, does a much better job of guiding you to the right result in these cases. So let's go to the next slide. What are some of the implications of a CDP hearing? Well, like I've already said a couple of times, it stops all IRS collection action if you're filing for this hearing timely within that 30-day time period. If the timely appeal is filed in tax court, it actually stays collection and through the decision of the court plus the 90-day appeals period after the tax court decision. It buys your client peace of mind and protection. They don't have to panic to think that their bank account is going to be wiped out the next day because you've just bought them a little peace of mind until you have the hearing and the appeals periods have expired. CDP hearings are usually and Bob, you may have a different experience, but they're usually scheduled within 2 to 6 months for us. Now, during the pandemic, we had some go out to 2 years, but generally things are getting back to normal. It's within 2 to 6 months for us when we request a CDP hearing from the date that we filed it. But it gives you time to investigate the transcripts, prepare any unfiled tax returns to make your client eligible for collection alternatives, and to fully prepare your defenses for the CDP hearing. Let's go to the next slide. If you want to file an offer in compromise or a tax settlement offer with the IRS, it's really advisable to make this offer in compromise request as a defense at your CDP hearing for a couple of different reasons. One, in my experience, it's expedited the processing of the offer in compromise. When the offer unit knows that an appeals officer is waiting for their decision on an offer, they seem to expedite those offers a lot quicker than my standalone offers that are not part of collection due process hearing. It allows a second review. Now, with an offer, you would always get the right to appeal, but you get I think, a more meaningful appeal with the IRS appeals officer is handling the collection due process hearing if the offer unit rejects or denies your offer in compromise. So that is another benefit. Also, it gives you the right to judicial review. You don't normally get judicial review if the IRS is considering your standalone offer. If they deny it, you get an administrative appeal. If you lose that administrative appeal, you're dead in the water on that particular offer. There's no more appeals process. But if you enter that offer as a collection alternative at your CDP hearing, you have the right to judicial review. So again, standalone offers don't have that right. Let's go to the next slide. So how do you do this thing? How do you request this collection due process hearing? Well, you've got to do it in writing. That's set out in the statute and that's set out in the IRS policy manual. How do you do it? Well, you can do it through a cover letter or you can do it through completion of the IRS form 12153. I would highly recommend you definitely use the form 12153 because the IRS, it confuses the IRS sometimes when you do things and they're looking for their specific forms. But I love the cover letter because the form 12153 doesn't give me a lot of room to write stuff. So I like to really outline my defenses at the CDP hearing. So my best practice is to prepare the cover letter and to fill out the form 12153. So I do both. Let's go to the next slide. So what are the contents of this hearing request package? Well, you want to include the copy of the notice giving you basically the jurisdiction or right to request the CDP hearing. So if it's the notice of federal tax lien filing or it's the final notice intent to levy, you want to include those documents. And I always attach our 2848 or our power of attorney appointing us as a representative. That's because even though I may have filed it with the IRS, maybe it didn't get logged my power of attorney didn't get logged onto the central authorization file unit. I don't want the IRS saying, hey, this hearing request wasn't timely because it wasn't requested by someone who had authorization to do so. My clients don't tend to sign the request for a hearing. We tend to sign it as the POA. So I definitely want to make sure I attach my POA, even if I've already filed it with the IRS CAF or central authorization file unit. Keep in mind, if it's a joint account and the notice intent to levy has both taxpayers' names, you want to include 2 power of attorneys, one for each of the taxpayers listed on the joint return. Complete and sign, make sure it's signed and dated, the IRS form 12153. Then again, I think the best practice is a written letter outlining your arguments and your defenses. You want to make sure you file it with the address that is directed in that letter. A lot of my students sometimes want to just pull the address on the letterhead, the IRS letterhead, but a lien notice often has a different address in the body of that letter as to where to make this hearing request. Why do you care if you're sending it to the IRS, whether it goes to the address in the body or the address on the letterhead? If you don't send it to the right address and it gets to the wrong office, you can deal with the argument. You may be successful in overcoming it, but you're going to deal with the argument that maybe the IRS would say it wasn't timely and they would try to switch you to an equivalent hearing. They have tried to do that to us in the past when an address was used from a letterhead. when a student was using a template, and that's one, it's a fight you can win, but it's it's one less issue you don't want to beg any issues here. So make sure that you read the letter and send it to the address directed within the body of the letter. If the IRS notice doesn't have an address, then call the telephone number on the notice and request a mailing address. So let's go to the next slide. Okay, so what do you include in this written request? We've talked about the things that we want to have here. Let's go on to the next slide. Some practice tips. Prepare a cover letter for what we talked about, summarizing your defenses. And why is this so important? And I want to take a minute and talk about this. Everything that you send to the IRS from the time you request the CDP hearing until you get your notice of determination after the hearing is part of the administrative record. If you have a conversation with the IRS appeals officer or the IRS appeals office, I highly recommend that you document it, that you put it in writing and you send it to them. I always do this because I know that everything that is exchanged from the time I request the hearing until the time I get the notice of determination is part of the administrative record. And we're going to talk about in a few minutes why the administrative record is so important. But you might be surprised sometimes too what the IRS will say to you over the phone, but they won't put in writing. So you definitely want to confirm things in writing. You want to confirm what you've sent to them. So I do a lot of what I call perfecting the record by sending out letters based on conversations, what took place at the hearing, and sending it out to the appeals officers. Next slide, please. So face-to-face hearings is another big topic. How can you request a hearing? There's a couple different ways that you can request the hearing take place, the form that you're going to have. Face-to-face is highly recommended. It's easy for the IRS appeals officer to say no to you if they're not looking at you. I have found in my practice before when my students have asked for hearings and they get a telephone hearing, it doesn't seem to go as well as if they have to look at you and really look at you face-to-face and have the hearing. So if you do not anticipate a controversy or need an appeal, you can later agree to a telephone hearing if you want to, even if you've already asked for one. In fact, if you ask for a face-to-face hearing, I often get a letter switching it to a telephone hearing, and it'll say in there, if you still want your face-to-face, give us a call within 14 days. And of course, I call and I follow up in writing saying we have requested our face-to-face hearing. But the Treasury Regulation 301.6330 allows the taxpayer to request a face-to-face hearing at the IRS appeals office closest to the taxpayer's residence. And there are some exceptions to this. And if the IRS takes the position that it's irrelevant or frivolous issues are being raised regarding liability, or the taxpayer has not filed the return, so they're not qualified for an offer, and that's what you raised in your cover letter as a defense, then they can try to refuse the face-to-face hearing in that situation. So if I'm raising a collection alternative, like I say, my client qualifies for qualifies for an offer in compromise or an installment agreement, I often try to send, especially for an offer, a collection information statement. If you're not ready to do the full 433A that's set out in the offer and compromise package, you can always send the 433F. You're just trying to show the IRS that your client maybe cannot afford to pay the whole tax liability and that they might qualify. And I do want to point out something. I have appeals officers that sometimes say, well, this isn't signed by your client, or this has not got a bank statement attached. You don't have to send information to show the document in its final form. You just have to send enough information to show so they can document their file that your client's potentially eligible for these collection alternatives. So if a client hasn't filed a tax return, I will note that in my cover letter to the hearing request and that we're preparing it and it will be filed within the next week. I will put that in there if it's not already filed. If it's already filed, I might include a copy of it. Let's go to the next slide. So the importance of the administrative record and scope of review and standards of review. There are different standards of review that I'll talk about in detail in a few minutes based on what's raised at the hearing, and based on your circuit, judicial review might be limited to the administrative record. Administrative record, again, we said starts from the time you request the hearing and your hearing request until the notice of determination or notice of decision, which is what you generally get with an equivalent hearing. It's not limited to the hearing itself. So prior to doing this, I was used to going into state court, and that's where you create your record, is in state court in the hearing in front of the judge. But one of the benefits of CDP, like I said, you're hearing the administrative record period is a much larger period, and everything that's going on during that process from the request to the decision is part of the record. Let's go to the next slide. So what matters can be considered at the CDP hearing? Next slide. You can dispute the tax liability or the assessment. Maybe you dispute it because a notice of deficiency has not been received by your taxpayer and your taxpayer disputes signing some type of waiver. Let's go to the next slide. So one of the biggest things, though, that you look at is an investigation requirement. And this is often an overlooked procedural challenge with people who are handling collection due process hearings. But at the hearing, the appeals officer has to verify that all the applicable laws or administrative procedures have been met. For example, the IRS is prohibited from assessing deficiency in tax unless either a notice of deficiency has been mailed to the taxpayer at his last known address, or the taxpayer or the IRS was allowed to bypass that through math error that Bob mentioned earlier, or the taxpayer signed a valid waiver of restrictions. So let's go to the next slide. So what does the IRS appeals officer have to do in that hearing to verify all applicable laws and administrative procedures have been met? Well, they've got to confirm the assessment is valid. That's where they have to go back and look and make sure they've sent out the right notices, the taxpayer didn't respond. They have to confirm a notice in demand has been made, that 10-day demand notice, 10-day payment requirement, and that demand notice when right after within the 60 days of the tax being assessed. They have to confirm the taxes are unpaid. And they have to confirm like that final notice of intent to levy or the notice of tax lien filing has been made. We had a case that went to trial that ended up in a published decision in the United States Tax Court that I'll refer to later, Marlowe versus Commissioner. And, you know, I will say I've been practicing about 10 years at that point. And my client said to me that they never received a notice of deficiency. They never received the right to go to the tax court. Well, a lot of my clients say that, and a lot of my clients are very transient and they've moved around. So no, they didn't receive it physically, but the IRS did send it to their last known address. So it, you know, we hear that a lot. So I, you know, don't know if it's accurate or not, but because the taxpayers raised it and I couldn't find records within the IRS to verify that that notice of deficiency had actually been sent to my client's last known address, I raised that issue at the CDP hearing. Well, the appeals officer at that point just kind of didn't give it a lot of consideration. She did look, she looked at the IRS computer and it said the notice had been sent out. And actually, I take that back. It said that statutory notice of deficiency had not been sent out, but the taxpayers instead on the audit notice had signed a waiver of the right for the notice of deficiency, a waiver of the right to go to tax court. And she said that was sufficient to convince her, just looking at her computer screen, that they did not have the ability to address their liability defense that they were claiming. As we'll talk about later, we appealed that to the tax court, and the IRS was never ever able to produce that notice. And even though we raised collection alternatives and we were hoping to get an offer in compromise of a couple $1,000s, we were able to show the court that assessment wasn't valid, that the appeals officer didn't do all she needed to do to confirm that the validity of that assessment, and it was past the assessment statute and the $50,000 tax liability we were trying to compromise. We didn't have to worry about that. The court found the assessment wasn't valid. It didn't need to be remanded back, and we won that case. So the taxpayer got out of the $50,000 amount that they really didn't think that they owed anyway. So it was a good result. So this verification of applicable laws and administrative procedures, I looked at this issue before, but I didn't really understand the importance of this issue and making these arguments until this case come up and what kind of benefit it could have for us. So, and that's Marlowe versus Commissioner that I think reference later on. Let's go to the next slide. So what does IRS appeals officer really need to do? Well, they're not required to look at one specific document to make that determination, or any one specific document. The form 4340 usually contains all the necessary information to meet that verification requirement. But if additional assessments have been made, that form alone is not good enough verification. If the taxpayer, as the tax court said, if a taxpayer contests this, then they can't just do a cursory look at their screen. They've got to go further. They've got to dig deeper to see if this assessment was valid. Let's go to the next page. So A failure to verify, here's the Marlowe citation I was talking to you about just a few moments ago. The court in Marlowe said a failure to verify that requirements of applicable law and administrative procedures were followed is an abuse of discretion. IRS had the burden of proof, and actually it was a de novo review of this whole issue in court, even though we raised it in the administrative collection due process hearing. So I will tell you the IRS was dead set, and that if their screen said that was the case, that was the case. And they did bring in 6 different IRS employees to testify that this assessment was valid. But they had the burden of proof, and we poked holes in all the testimony that we saw. So again, this is a fun area. If you like to litigate, or you want to litigate and try to make some clarification of the law, this is a good way to do it. Let's go to the next slide. Okay, so what are the issues that are actually considered at the hearing? Let's go to the next slide. We talked about the matters. Now here's the issues. Generally, a person can raise any relevant issue relating to the unpaid tax or the proposed levy. Let's go to the next slide. Now that you have this broad statement, let's see how it's, you have to pull back a little bit. But what are the issues that are outlined in the statute? Well, you can challenge joint liability, which under 6013, whether there should be a joint liability. This is a case where your client saying, hey, there's a joint return. I didn't agree to file this joint return. There was no intent to file this joint return. And you could bring up that challenge at the hearing. You can bring up innocent spouse relief. Yes, my client filed a joint return, but we don't think she or he should be held liable for this joint and several tax liability. And here's the reasons why, which is basically innocent spouse relief or relief from joint and several liability under 6015. You can challenge the appropriateness of the collection action. Maybe what the IRS is doing goes beyond what they should be doing. This happens a lot with the lien. I have the IRS send out the notice of tax lien filing. My clients have no excess monthly income, maybe only income is Social Security benefits. They're in economic hardship, and they have no assets and no ability to purchase any future assets. So what purpose is that lien serving? So I will challenge the appropriateness of the lien at the collection action at the hearing. And you can raise collection alternatives. Next slide. So, Bob, and feel free, I know you worked a little bit on this before, feel free to kind of intervene here, but at the hearing, taxpayers can raise issues regarding the underpaying underlying tax liability. Bob, did you want to say anything here?
No, why don't you go ahead? You know it as well as I do.
Okay, well, you drafted some good slides, so I just want to give you the opportunity because I know you know this really well. But you can raise a challenge regarding liability, but it's not an unlimited right to do that. It is restricted here. You can only do this if your client didn't receive the notice of deficiency for the tax liability or didn't otherwise have an opportunity to dispute this tax liability with IRS appeals. Let's go to the next slide and kind of delve into this a little further. Well, before we get to that, I think that there's a slide here on issues. Currently not collectible placement. You can raise that issue at the hearing. That's where you show your client is in economic hardship. They're exempt from the levy under Internal Revenue Code section, maybe 6343 A1D, or that, and you know, whether the IRS, the taxpayer qualifies for currently not collectible, which doesn't get them out of owing the liability. It just means the IRS has to stop collection action due to their economic hardship at the time. Maybe they qualify for certain exemptions from the levy. For example, usually a personal residence, unless certain procedures are followed, the IRS doesn't or can't go after a personal residence for levy. So there's a list in the statute of all of these different categories that is exempt from levy, and maybe that's something that you want to raise at that hearing. So I do want to say here, IRS on one of our cases back in 2009, this Vinatieri case, the IRS said that our client they couldn't put my client in currently not collectible status, and they couldn't stop the levy, even though they agreed after seeing a financial statement that she was suffering economic hardship. And 6343 A1D says, hey, if the taxpayer is facing economic hardship, then the government, needs to remove the levy or proposed levy. And the appeals officer said, yeah, we see that, but our Internal Revenue Manual provision says that regardless, they have to be compliant before we're going to do that. Well, that compliance requirement was not in the statute. And so this went to court, and the tax court said a levy can be removed, a proposed levy can be removed, or an actual levy when the taxpayer even if the taxpayer is not compliant with filing their tax returns. as long as they're facing economic hardship. So that is an opportunity we had to have some clarification of the law, but that's the Vinatieri case. So if the IRS, if you've got a client facing hardship and they say, and this still happens, even though that's been, 13 years ago, I still have from time to time this issue come up, and the IRS has even revised their Internal Revenue Manual to say now taxpayer doesn't have to be compliant if they're in hardship for you to agree to withdraw the proposed levy, but it still happens. So that's the case that would help you with that argument if that occurs in that statute. Let's go to the next slide. So here's where we really go back to getting into the nuts and bolts of whether you can dispute the tax liability, the underlying tax liability. Next slide. So it really depends on the events that have already taken place. But if you didn't otherwise have an opportunity to dispute the liability in appeals, then you might be able to challenge the liability at the hearing. If your client didn't receive the notice of deficiency in time to petition the tax court, then you might be able to. Let's go to the next slide. So here's why I really want to dig deeper. When the statute says the client didn't receive the notice of deficiency, the Treasury regulation makes it really clear that it means receipt of the notice of deficiency means receipt in time for the taxpayer to petition the court. This is my favorite thing to do at, we have consultations with taxpayers the day that their cases are calendared for subsequent trial, and then the court calendar is set. And these are the cases that I often find myself entering an appearance or having my pro bono attorneys enter an appearance, was when the taxpayer tried to raise a liability issue at the hearing, and the appeals officer said, no, we sent you a notice of deficiency. Well, that's the correct standard, sending the notice of deficiencies to the last known address for somebody to timely petition a court in response to the notice of deficiency, but it's not really what the standard that's laid out in this Treasury regulation at a CDP hearing. So if the IRS is not able to show that my client received it in time to petition the tax court, and my client can make a good or a credible argument as to why they might not have received it, then I can actually enter an appearance in the court, put my client on the stand, and I elicit credible testimony, and then I can ask the court to remand it back to appeals because appeals refuse to consider the liability issue. So I don't have to be fully prepared to try the case, but I can jump into a case at the court calendar and raise this issue. The IRS seems to be confused, the appeals officers mostly, about this particular this issue. So I generally ask the IRS, and when it's at court, I ask IRS counsel, do you have proof my client received it? Well, no, we have proof that it was sent certified, but we don't have proof that your client ever received it. And then I put my client on the stand. Maybe my client was a traveling salesman. Maybe my client was very transient and had moved around a lot. But we elicit some credible testimony, and then we get it remanded back to appeals, so we can actually have a hearing dealing with the liability issue. Because, and I'm sure Bob would probably agree with me on this, the appeals office, settlement officers and appeals does not like to deal with liability issues at the CDP hearing. They want to kind of, I think, put everybody in the category of collection alternatives. So, and it's, I think it's just a way to try to get, they have a lot on their plate with a huge inventory and just to move cases along quicker. But there's nothing worse than a client working with a client and getting a client to agree to a collection alternative because they won't, well, a lot of times if they don't think they owe it. And they'll shut down. And that's a lot of the cases that I pick up at the court calendar because they refuse to talk about a collection alternative because they don't owe the tax liability. And so if you can get that liability challenge considered, you would definitely want to do so. And that's the only way a lot of times a client will feel they've had a fair shake at this. So I asked the IRS attorneys for a mailing list to show that it was sent certified to the last known address. And I asked for proof that the taxpayer had signed for it, and they don't do the return receipt, or I've never been able to get that return receipt and show that they signed for it. So I then put on my client on the stand, get that credible testimony, and we get it remanded back to the appeals officer to consider the liability issue. Now, an opportunity, and that, remember, in the statute, you can bring up the liability issue if your client didn't receive that notice of petition, notice of deficiency in time to petition court, if they've had a prior opportunity to dispute the liability with appeals, then they're going to be blocked from bringing up that liability issue. Let's go to the next slide. And I know Bob worked on this and put together a really good slide because the law is not as clear as it should be in this area. So it's what we have to do is figure out when the courts have said this is a prior opportunity and when to dispute this with appeals and when it's not. A 30-day letter in deficiency cases is not a prior opportunity. An opportunity to file an amended return is not. A math error notice is not. Opportunity to file a refund claim is not. Audit reconsideration is not if the appeals conference was not offered after the determination. And a preliminary determination in an spouse claim is not as well. Let's go to the next slide. But what is a prior opportunity is if you've had another collection due process hearing. And let me warn you about something. If the IRS sends a lien notice out, notice of tax lien filing, and a notice of intent to levy, if you get that lien notice first and you don't respond to it, it's my experience and observation that the IRS will argue that that was your prior opportunity and you didn't raise it, and therefore they don't have to consider it in the levy if you're filing the hearing request in response to the levy. So watch out for that. If you got audit reconsideration and they gave you an opportunity for an appeals conference, then that was your prior opportunity. And of course, like they were arguing in my case, even though my client didn't get a notice of deficiency in Marlowe, they were arguing my client had signed a waiver form or an 870 form, and therefore they don't have the opportunity, they didn't get the opportunity to dispute the tax liability. Let's go on to the next slide. So a few practice tips. I always ask the appeals settlement officer for a copy of the deficiency notice and the certified list and maybe proof. I'd ask them proof that it was received by the taxpayer. And this is the issue I talked about. If your client receives the lien notice, but they wait and then they get the levy notice and ask for a hearing, then you're going to have an appeals officer that's probably going to argue they've already had a prior opportunity to raise the liability issue with respect to that lien notice. Let's go to the next slide. Now, a spousal defense is not considered as a dispute regarding the existence or amount of tax under the Treasury regulation. That's something we've had some fights with the IRS over. And a taxpayer can't raise the spousal defense if only when they've had a determination on the spousal defense in the tax court. Let's go to the next slide. Now, one thing that a lot of people don't know that deals with these CDP hearings is even if you are precluded, you cannot raise the liability because your client received the notice of deficiency in time to petition the court, or they had a prior opportunity to deal with this with appeals with a liability issue. That appeals officer still has discretion in the statute to consider the liability. It's not subject to judicial review, but you can reference this Treasury regulation that I have on this slide, and you be prepared to educate the appeals or settlement officers that they have this discretion because they won't offer it. But just you can still get that liability issue dealt with and your client satisfied and maybe, no tax liability owed. But whatever decision the appeals officer makes or settlement officer, it is not subject to judicial review because they're under the statute they didn't meet those two requirements, or they'd had a prior opportunity or they'd received a notice of deficiency in time to petition the court. So just know that. But I still get appeals officers to consider liability issues that are no longer before the CDP hearing. It's just done outside of the CDP hearing. Next step, or next slide. So quickly, some collection alternatives, and then we're getting ready to hear from a real exciting speaker on some developments in this area, but if we'll go to the next slide. Collection alternatives that you can make at the hearing, your installment agreement with monthly payments, offering compromise, you can post a bond, or a substitution of assets. We'll go to the next slide. And some considerations at your CDP hearing. We'll go to the next slide. I think it's not advisable. Now, some other people may think it is, but I rarely bring a client to a CDP hearing. The IRS can ask your client questions, and if your client gets nervous or confused, their answers may not match what's on the collection information statements you've already provided, and your case will lose credibility unless you can quickly save the day. And so I found after taking a couple of clients to CDP hearings early on, it's better not to take the clients to the CDP hearings. And here's the biggest problem I ran into on a couple of cases. I don't want the IRS representative to judge the client's physical or mental impairments. They're not in the role of a doctor. And if I presented medical records that they are unable to work, and then they should be following the medical records of what the doctor said. They don't need to be making their own assessment by looking at my client and say, oh, my client looks like they're able to work. And I had that problem in a couple of CDP hearings when I first started practicing. So that's another reason that I don't bring a client to a CDP hearing. Next slide. So what do you do if the IRS asks you something that you can't answer or ask something about your client? Well, you can always offer to bring an affidavit or a declaration and send it to the IRS appeals officer. They'll give you time, 7 to 14 days after the hearing, because remember, the record's still open, and you can ask the client the questions you don't know the answer to. So that's that's how you can compensate for not having the client there to answer those questions. And you can, of course, do it under in an affidavit form or declaration form that there's attesting under penalties of perjury. Next slide. So APA, the formal hearing procedures don't apply in CDP hearings. They are informal, but a transcript can be made of the hearing, but it's not required. I've taken transcript reporters to hearings when I knew it's highly contentious and I knew we were going to probably go to tax court, but it's not cost effective. So I only do that when I really have a good indication from prior conversations with the appeals officer that they're not going to consider something, or they're not going to follow the law, or when I feel like they're not following the law. So then I'll take a court reporter. But even if you don't take a court reporter, let's go to the next slide. You don't have the right to subpoena and examine witnesses. Like I said, you can take affidavits. Let's go to the next slide. One thing I want to say, and I think it's on a later slide, but you do have the right to record. But if you record, you have to give them 10 days notice, and they have the right to record as well. So if I don't take a court reporter, I do take a recorder, and I have given them 10 days notice, and I record the hearing. So forums for CDP, you can do face-to-face. That's at the IRS office closest to your taxpayer. I don't often do face-to-face anymore because I use virtual. They can do Microsoft Teams or Zoom, and you can have a good face-to-face hearing that way, which makes it harder for the IRS to deny your request because they have authorization to do these hearings through Teams or Zoom. Telephone, not preferred method because it's easy for them to just discount what you're saying and make a determination based upon what they saw on the record. Mail, not preferred. Next slide. So building the record, as we've talked about, is really important for judicial review. Next slide. This is where we talk about taking a court reporter. Let's go to the next slide since I've already talked about this. Let's go on to the next slide. Let's talk about the notice of determination before we end this section. Next slide. So unless your client signs a written withdrawal request for the CDP hearing, or unless they sign a summary notice of determination surrendering their rights to judicial review, the IRS is required to send out something called a notice of determination. And I think it's a notice of decision with an equivalent hearing, but they're required to send it out, this notice of determination, by certified registered mail or registered mail. Next slide, please. And what does it include? You can look over the slide, but basically, whether the IRS has met the requirements, did they make sure they follow the law and procedure in making that assessment? Did they resolve any issues that were raised by the taxpayer? Did they make a decision on any spousal defenses like we talked about? Did they consider your collection alternative of an offering compromise or installment agreement? But here's the biggest one to focus on, because here's where I feel sometimes the IRS doesn't get it right. Did they address whether the proposed collection action represents a balance between the need for efficient collection of taxes with the legitimate requirement that are concerned the taxpayer, but that collection action be no more intrusive than necessary? Now, they stamp this particular paragraph at the bottom of their notice of determination. But what I find is a lot of times when I look where they've recited the issues that we raised, there's no connection. And if they made that connection, like on a lien, for example, with a client that has nothing and no ability to purchase anything in the future and is facing hardship, then why are they going forward with that lien? And that's so that, you know, that's standard. And when I appeal to the court, I often focus a lot on this fifth item here that's bulleted, because I feel like this is where they get it wrong sometimes. Any agreements that are reached should be listed in that determination letter, any relief, and any actions the IRS or the taxpayer is required to take. Next slide. So then that's where we talk about that standard. They have to do that balancing test. Next slide. So appeals to the tax court. Look at the next slide. You've got 30 days we've talked about. Oh, the appeals office does retain jurisdiction of the case after it goes to the tax court, and the stay on collection extends for most matters through that appeal. Next slide. In seeking the review, the taxpayer really is limited to the issues that are raised during the hearing. Next slide. So, then I'll end on this. Appeals to the tax court, standard of review and burden of proof. I know it says burden of proof here, but I also want to talk about standard and scope of review in just a moment. So the standard of review for innocent spouse relief is kind of the same standard they follow under the statute for reviewing a standalone innocent spouse relief case. But when you're looking at procedural requirements, did the IRS make sure that that assessment was done right, or investigation requirements? it is an abuse of discretion determination, but a de novo review. So on Marlowe, for example, when we said the IRS didn't verify that that assessment was legally made, we got a de novo review, and the court found in their decision there was abuse of discretion, but we got a de novo review, and the IRS had the burden of proof in that case. Now, if you're raising a liability issue, you get a de novo review, but the taxpayer still has the burden of proof. If it's a collection alternative, then they're looking at it under an abuse of discretion standard, and it's a lot harder to win. And the taxpayer has the burden of proof. And I think most of us know kind of what abuse of discretion is, whether it was done arbitrarily, capriciously, or without basis in fact. So let's go to, let's go to the next slide. Before we talk about remands, I want to talk about scope of review. I talked about standard review, but scope of review is different. Scope of review talks about what the IRS, whether they're limited to the administrative record. And I will tell you the United States Tax Court's position on this is that review is not limited to the administrative record. I have had and the IRS raises it every time in our cases. It doesn't matter whether we're in a circuit or not, that where the circuit courts have said that the review is limited to administrative record, they always raise it. And the tax judge's response has always been, we take the position that it's a review of the CDP hearings are not limited to the administrative record, and they allow additional testimony, additional documents to be introduced. But the 9th, 8th, and 1st circuits may limit review to the administrative record. There is cases that do that. And of course, the IRS's position is that it's always limited to the administrative record. They always bring that up, and they do have support in the 9th Circuit, which we're talking to you guys today that are in the 9th Circuit. 8th Circuit and the 1st Circuit. So they do limit review to the administrative record, which again makes it all that more important that you have a good administrative record. Remands are a way of getting IRS appeals to reconsider the case. IRS counsel attorneys seem to be pretty agreeable to remands if the record's insufficient, and there's case law to support that the court can order the remands if the record's insufficient for judicial review. If you can show that remand would be helpful or productive, or you can show appeals made a mistake that's not just harmless error, or my favorite one, there's a change in circumstances. Next slide. And the next 2 slides are just going to give you some possible remand scenarios that I've talked about, like, and when the courts have found in the court cases that support when these remands would be awarded by the court. Let's go to the next slide. And again, there's some other situations and some case law to support that. Next slide, please. Next slide. And there's some cases where the courts looked at whether a remand for a change in circumstances would be valid, such as in Churchill and Van Kamp and Kehoe. Let's go to the next slide. And here's where the courts have said, here's some particular cases that maybe remands are not appropriate. In our case, the court said a remand was not appropriate because there was no other documents out there. The IRS had lost what they claimed was the notice, the waiver notice that was signed by my client. So the court said, we're just going to go ahead and rule. We're not going to remand this back and find that that assessment wasn't valid. But in other times, they may say that it's not appropriate because taxpayer was given every opportunity. They didn't even show up for the maybe CDP hearing, and therefore it's not appropriate to remand it back. Next slide. Okay, so now I'm going to turn it over to the next speaker, who is going to talk a lot about some of the current developments in tax court.
So up until now, Bob has brought us through pre-CDP, how we get there, into the CDP process. Mary talked about us going into tax court potentially after a CDP determination. Now I'm going to hone in on a specific issue and a really important practice point for if you're going to tax court, and that is jurisdiction. So I'm going to start just generally talking about jurisdiction in the tax court, where the authority comes from, what type of matters there are to consider. We're then going to talk about the procedural issues that could give rise to jurisdiction or potentially get your case dismissed if you don't comply with certain procedures. And finally, we're going to talk about one of the most recent cases addressing jurisdiction from the Supreme Court, and then another case that's making its way through the courts at the appellate level. So just to start off, next slide, please. So the tax court, the U.S. tax court, derives its jurisdiction from section 7441 of the IRC, and Congress passed that statute and had the authority to do so under Article 1. So here we're dealing with an Article 1 court as opposed to an Article 3 court. And the IRC 7442 generally grants jurisdiction to the tax court to hear different tax matters But then on top of that, there are actually specific grants of jurisdiction interspersed throughout the IRC code. Next slide, please. So here are a couple of those. This is a non-exhaustive list. There's many others of the specific grants of jurisdiction interspersed throughout the IRC. Some of those are joint and several liability, redetermination of interest, but the two of strong interest and relevance to us in this presentation are the last two. Mary alluded to this earlier, the last one being review of collection due process cases. There's a specific grant of jurisdiction to the tax court to hear these matters. Another semi-relevant one is the enforcement of overpayment decisions by the tax court if they're not refunded by the IRS. This comes up in a case of Colt v. Commissioner, which was just decided in the Third Circuit, and this was raised as a jurisdictional basis in that case. So these are the two relevant ones for today. But again, this is a non-exhaustive list. There's many specific grants of jurisdiction throughout the IRC. Next slide, please. So with that background in mind, that's the basis for the jurisdiction of the tax court. One really important practice point is looking at the procedural requirements that give rise to jurisdiction. In essence, there's different procedural requirements inside statutes in the IRC that you must comply with in order for the tax court, and the tax court must comply with them in order for the tax court to actually have jurisdiction over certain matters. And Mary alluded to some of them earlier on slide 51. She talked about how she attaches a notice of federal tax lien filing before a CDP hearing. That's one of those requirements that you have to comply with for the CDP hearing, for there to be proper jurisdiction in that hearing. Other examples are a notice of deficiency. This is most commonly referred to as your ticket to the tax court, because for the tax court to have jurisdiction, there first must be a validly issued notice of determination. Other procedural requirements that you must comply with for the tax court to have jurisdiction are filing deadlines, and that's the most relevant one to today. And we can see the example here, section 6330D1. This is the one relevant to CDP hearings. After a CDP determination, a person may, within 30 days after such determination, petition the tax court. Right here, underlined, we can see within 30 days. That establishes a filing deadline that the taxpayer must comply with to go to the tax court and file a petition within that 30-day timeline. Later on in that sentence, you'll see in parentheses, and the tax court shall have jurisdiction which with respect to such matter. So you can now see in play in this statute is the fact that comes after a CDP determination. That's a procedural requirement, has to come after that point. Then you see the 30-day filing deadline. That's another procedural requirement that the taxpayer must file within. And at the end, we see an interesting kind of addition here. The tax court shall have jurisdiction with respect to such matter. And this gives rise to another question with respect to procedural requirements. And we break up procedural requirements into two general categories. They can be jurisdictional or they can be non-jurisdictional. If we call a procedural requirement jurisdictional, that means it's in essence a harsh rule. That would mean that if there's a 30-day filing deadline in an IRC statute, you must comply with it. And if you're late, then you're late. There's no jurisdiction in the tax court. The tax court will lose jurisdiction. It cannot equitably toll or give you any credit any of your excuses. So that's what we mean when we call a procedural requirement jurisdictional. Harsh rule, must comply with it. On the other hand, we have non-jurisdictional filing deadlines and non-jurisdictional procedural requirements. That would be, for example, the same 30-day filing deadline, but if it's considered non-jurisdictional, then the court can extend it. If you have a valid reason, for whatever reason, you go to the tax court, you file on the 31st day, 1 day late, but it's a non-jurisdictional filing deadline, the court may be able to equitably toll that filing deadline and allow you to proceed. So it's very important to determine whether a filing deadline is considered jurisdictional or non-jurisdictional, because the implications are huge with respect to the jurisdiction of the tax court. If you miss a jurisdictional filing deadline, you'll be bounced out of the tax court for lack of jurisdiction. But if it's non-jurisdictional, you may have the opportunity to plead your case for equitable tolling, and the tax court can still retain authority over that. Looking at the current trends, before 2006, the Supreme Court, appellate courts, tax courts would have essentially review filing deadlines and procedural requirements in a very cursory fashion. They'd make, quote, drive-by jurisdictional rulings in which they would just address substantive matters, substantive tax matters or other legal matters, and just in a cursory fashion, run over and consider these filing deadlines to be jurisdictional, applying that harsh rule. After 2006, in a case Arbaugh, the court took a step back, that is the Supreme Court, and started reevaluating these filing deadlines and procedural requirements. And now there's a different standard of review looking at these issues, And there's been a shift in the Supreme Court thinking, and there's now the strong presumption toward filing deadlines being not jurisdictional. So the court's reevaluating that, and that's the backdrop to this recent case in April 2022 of Beckler v. Commissioner. Next slide, please. So from 2006 all the way to 2022, there's been about 14 or 15 cases in which the Supreme Court has evaluated procedural requirements. And the trend has been the court looking at these formerly jurisdictional procedural requirements and recategorizing them, in essence, as non-jurisdictional. So this case of Beckler, which addresses section 6330D1, which is that statute we just talked about related to collection due process, in this case looked at the filing deadline from 6330D1. It's that 30-day filing deadline that a taxpayer must file within 30 days after a collection due process determination. And the question was, in essence, is this filing deadline, this 30 days, is it jurisdictional? Should we apply that harsh rule? Or is it non-jurisdictional? And can we allow equitable tolling? And that's basically the crux of this case of Beckler v. Commissioner. And the facts are, there's a law firm in Fargo, North Dakota. This law firm was issued a couple notices. As Bob alluded to, there's a whole process of notices from the IRS. And Beckler law firm went through this whole process. Eventually, a penalty was assessed. They had a CDP hearing. And then after the CDP hearing, according to 6330D1, they had 30 days to then file a petition with the tax court. They filed on day 31. So that sets the stage for this legal issue. Whether, if it is in fact jurisdictional, this 30-day filing deadline, then Beckler should be bounced out of the tax court for lack of jurisdiction. On the other hand, if it's not jurisdictional, even though they filed on day 31, the court may be able to equitably toll it and allow the case to proceed in the tax court. The procedural history was the tax court unanimously said, no, we cannot hear this. It's a jurisdictional filing deadline. We cannot hear this, and the case dismissed. The 8th Circuit affirmed this, and ultimately it reached the Supreme Court on cert. Next slide, please. So again, these are the core issues. Number one, is this filing deadline jurisdictional or not? In order to then reach issue 2, the first question must be answered in terms of the filing deadline being not jurisdictional. Meaning, if the filing deadline is not jurisdictional, then only then we reach issue 2, which is then, if it is not jurisdictional, is it subject to equitable tolling? So this is a two-part analysis. One, determine is it jurisdictional or not, and then only reach issue 2 if the answer to issue 1 is that it's not jurisdictional. Because if a filing deadline is not jurisdictional, it's not automatically subject to equitable tolling. It may be subject to equitable tolling. Next slide. So honing on an issue 1, the court explained basically what we just talked about in the past couple slides. It said that there are procedural requirements limiting the court's authority, but not all of them are jurisdictional in nature. There's 2 different categories. And the jurisdictional one does not allow equitable tolling. Non-jurisdictional, also known as claim processing rules, do allow equitable tolling. And the court then honed in on, how do we know when a filing deadline is jurisdictional or not jurisdictional? And the court, dating back to Arbaugh in 2006, all the way up to Beckler, has continued to refine and apply this analysis. And it's a 2-part analysis to determine whether a filing deadline is jurisdictional or not. The first part is there a clear statement? In essence, the court looks at, did Congress clearly state that this filing deadline is intended to be jurisdictional? That's question 1. And then as a fallback, if number 1 is not fulfilled, the court will then look to whether there's a long line of Supreme Court history holding that this filing deadline is in fact jurisdictional. So there's basically 2 paths forward to show that a filing deadline is in fact jurisdictional, and at least one of them must be fulfilled. Next slide, please. So addressing number 1, the question is there a clear statement by Congress stating that the 30-day filing deadline in section 6330D1, is it jurisdictional? And here's the statute, bringing it up again here on the slide. And you'll see again, we clearly see the person may, within 30 days of a determination, petition the tax court. 30 days, that's the filing deadline at issue for review of such determination. And the tax court shall have jurisdiction with respect to such matter. Interestingly, you'll see the word determinations used once, determinations used twice, but in the final sentence, we see that the tax court shall have jurisdiction with respect to such matter. There's a change in verbiage there. Also notable is the fact that the filing deadline within 30 days of determination applies, arguably, this is what Beckler argued, to the person immediately before it. So in essence, Beckler argued that the 30 days is applying to the person as opposed to applying to the jurisdiction, the tax court. So those essentially were the arguments here. The fact that determination was used with respect to the 30 days, the fact that the 30-day filing deadline was applying and modifying the person as opposed to the tax court jurisdiction. These were the arguments that were levied by Beckler, and the IRS, of course, argued the other way, arguing that 30 days applies to the jurisdiction of the tax court itself. Next slide, please. Ultimately, on this issue, the court determined there was no clear statement in that statute because of the different verbiage using such matter versus such determination, because of the modification of the antecedent, the 30-day filing deadline applying to arguably the person instead of the tax court, using all these statutory constructions, also looking at some previous precedent in history, the court determined there is no clear statement here. The court also looked at contemporaneously enacted statutes. In essence, they said, hey, look at section 6404G1, look at 6015EIA, these other tax statutes that were passed around the same time as 6330D1. And if you look at these other ones, it's very explicit when Congress wanted to apply a really harsh jurisdictional rule. In those statutes, the framing is basically the tax court has jurisdiction if such action is brought within 30 days. There's a very clear delineation and linkage between the filing deadline and the tax court's authority. Whereas in this statute in Beckler, 6330D1, there was a pretty big breakup between the filing deadline and at the end of the sentence, the tax court jurisdiction. So ultimately, the court said no, the Supreme Court said no, there's no clear statement dictating that the filing deadline is jurisdictional. And then the court also entertained briefly the argument by the IRS that past precedent, citing appellate court history, tax court history, the Supreme Court said, no, we're not going to accept that. We're only going to credit a long line of Supreme Court history and not appellate and not tax court history. That was the IRS's attempt to fill that second lane of analysis, trying to prove there's a long line of Supreme Court history. And the court said, no way, we're only looking at Supreme Court, not appellate court, not tax court opinions. Next slide, please. So now that we answered question one, we already determined that the filing deadline in 6330D1 is not jurisdictional. We can now move on to the second question. Now, is this non-jurisdictional filing deadline subject to equitable tolling or not? Automatically, you start with a strong presumption. It's not automatically granted, but you do start with a strong presumption that says, yes, equitable tolling applies to non-jurisdictional statutes. That comes from the case Irwin v. Department of Veterans Affairs, and it's a strong presumption. And in Beckler, the court ultimately said the IRS was not able to rebut that presumption and held that equitable tolling does apply. There's one strong case in the IRS's favor in this case, and the IRS continues to cite this case in related tax matters of this nature, and it's US v. Brockamp. This was essentially a case where the court said the filing deadline with respect to refunds, tax refunds, was not jurisdictional, but the presumption would not stand. They said equitable tolling cannot apply. The rationale was tax refunds and this late filing deadline affected 90 million plus taxpayers each year and would create huge administrability concerns for the IRS. In Beckler, the court looked at the situation, determined it was about 30 to 40,000 taxpayers that would be affected by 6330D1's filing deadline, and said that's not even comparable to the 90 plus million that was at issue in US v. Brockamp. So looking at the administrability concerns and balancing those comparisons, the court said that wouldn't be an issue and the Irwin presumption still applied there. So in the end, next slide, please. So in the end of Beckler, the court determined the filing deadline for 6330D1 is not jurisdictional and that equitable tolling did in fact apply. So the case was then remanded back to the tax court, and the tax court did in fact have jurisdiction. And it was up to the tax court to then decide, based on the facts of the case, should we give equitable tolling to Beckler law firm because they filed 1 day late. So that was the culmination of Beckler. And Beckler has now really opened the door for other filing deadlines in the IRC to be challenged. And one of them currently making its way through the court is the case of Culp v. Commissioner. This addresses the 90-day filing deadline in section 6213A. And this is related to taxpayers' ability to file a petition with the tax court for redeterminations of deficiencies. And basically is looking at this statute and arguing based on the Beckler logic, we should now apply this framework of a clear statement, as well as then an analysis of whether there's a long line of Supreme Court history. And ultimately, the Third Circuit applied the same logic from Beckler and determined that this filing deadline of 90 days is also not jurisdictional. This case was decided yesterday. So it was a victory for the taxpayers, and it actually creates a circuit split now with the Ninth Circuit, and I believe it's 11th Circuit. So right now we're waiting to see what the DOJ does, whether they seek review, appeal to a full panel in the Third Circuit or appeal directly to the Supreme Court. But this is possibly going to have the same outcome as Beckler if it reaches the Supreme Court. And that's all I have on this one.
Great. We've reached if we could advance the next slide, please. We've reached the end of this session on collection matters affecting low-income taxpayers. I want to thank the panelists for putting together just remarkable materials and spending this hour and a half with you. I urge you to join with LITC Connect if you're interested in doing pro bono work. And thank you for your attendance today.